Welcome to the No Say Project channel. I'm Mark Stevens. I want to do a video here, kind of an analysis, because another Republican has lost on these allegations of massive, widespread voter fraud and vote rigging. I'm talking, of course, about Kari Lake. Unfortunately, she is here from Arizona, where I happen to live. And so Kari Lake, she was running for governor, and she did not win. So, of course, like Donald Trump, she is crying foul. So it's the whole new thing that if I don't win, it's rigged.
Because the only way we're going to lose this election is if the election is rigged. Remember that.
So I'm not going to spend any time on, it's not even necessary to spend any time on what faulty logic that is. Unless I win, it's rigged. So right there, anybody supporting that just doesn't have a really good foundation in basic logic. Like Trump, now she doesn't have quite a track record as Trump. Trump filed over 60 lawsuits and lost, I think, all but one. And in the one that it wasn't tossed down for being frivolous, nothing really materially affecting the election anyway. So bigly time. So Trump, loser, big league.
Big league.
So Kari Lake, loser, not so much. So she's crying foul, of course, because the only way she believes that she could have lost was if it was rigged. So she really is just a sycophant for Donald Trump. The same stupid things you'll hear from Trump, you'll hear the same things from Kari Lake.
Go and take a look at the oranges of the investigation.
And it is no surprise that her complaint got thrown out. And this is right there from the clerk of the court, maricopacounty.gov. This is also, I'm doing this because I got a comment the other day where somebody was saying, why am I pointing out that, Trump lost another lawsuit? The judges throw complaints out every day for being frivolous, including mine. Yes, but there's a major difference between Kari Lake and Trump and people like me. I'm a nobody. I understand that, all right? I accept it. I don't cry foul when I don't get views, when I don't, okay? I accept I'm a regular person. I'm a regular guy. No big deal. They're not. I wasn't running for governor. She was. I wasn't running for president. I'm not a former president. Like I said, I'm a nobody. It's a very big deal when an elite gets something thrown out against them for being frivolous. Because there's two tiers of justice, so-called, here in the United States and in most parts of the world. Any half-idiot knows that the rich get very, very, very preferential treatment. They're almost never held accountable. Trump took hundreds of classified documents. Still walking around free. So money has its privileges, and Kari Lake is very rich. And she's running for governor. And she did pretty good, considering how crazy her arguments are, her claims. But there are certain standards that the courts do maintain. And again, I've been in court cases where I can show very clearly they didn't have any evidence and they admit they had no evidence. But I was going against the elite. I was going against the IRS. So judges are very preferential there. So it is a very big deal when one of the elites gets their complaint tossed out. And we even know that a lot of Trump lawyers were sanctioned. Rudy Giuliani, I think, the Sidney Powell, they were sanctioned for bringing frivolous lawsuits. I have never been sanctioned for a so-called frivolous lawsuit because I tended not to bring, I was really usually just the one calling out that a complaint against me or someone I was working with was frivolous. So here, a Republican judge, or he was nominated by Jan Brewer, a Republican, Peter A. Thompson. And that's another thing. A lot of the judges that rule against Trump and continue to rule against Trump, he nominated. They, for them to stick to the rules, it's got to be bad. So you got Kari Lake against Katie Hobbs, who is the Secretary of State, who's now going to be the governor here. Contestant Kari Lake initiated this election contest with the filing of a complaint in special action and verified statement of election contest, naming defendants Katie Hobbs personally as contestee and in her official capacity. So what the judge is looking at here is pending before the court are 3 motions to dismiss. Of course, she's claiming voter fraud, irregularity. She was robbed. So a lot of this are things that people who are familiar with the channel know I've said these things for a long time. I just wish they applied across the board evenly, that justice really was blind, that judges would actually apply these principles. Sadly, they don't. A motion to dismiss ought to be granted if there is no interpretation of the facts alleged in the verified statement susceptible to proof that entitles the plaintiff to relief. The court assumes the truth of well-pled factual allegations and will indulge all reasonable inferences therefrom. I like this part. I like it a lot, because I almost never applied this when I filed a motion to dismiss. Allegations consisting of conclusions of law, inferences, or deductions that are not necessarily implied by well-pleaded facts, unreasonable inferences, or unsupported conclusions from such facts, or legal conclusions alleged as facts are not presumed true. Of course, like I've shown hundreds of times where if it's the IRS, they can make a conclusory statement. The judge accepts it as true. And even if you have evidence to contradict the sworn testimony of the IRS agent, their own words, and you have them pled, you transcribe your audio recording, then they won't admit it. They just keep saying, no, conclusory statements, no evidence, I got a CD. So these are really good points. This is black letter law, basically. This goes back, there is no disputing this, what the judge is using as support. This is really, really basic stuff for a motion to dismiss and for what's necessary to be in a complaint to be able to get over, to prevail over a motion to dismiss. Well-pled factual allegations, not unreasonable inferences or unsupported conclusion. So here we've got one of the elites where the judge is applying the law as they're supposed to. Well, the rules here, the rules of court. I'm not going to go through everything because it's be a 2-hour video. But what I'm going to go is just go through this section I've already run through and this legal standard, which I agree with. Great. Just please, again, my position is please just apply it across the board, regardless of who the defendant and plaintiff are. To the extent that the verified statement raises the Arizona Constitution's independent and broader guarantee of free speech, they do not defend this argument in the briefing. So they don't have any facts. They're making a conclusory statement, but they're not backing it up with any facts. Moreover, even if plaintiff successfully pled a First Amendment challenge, she cannot argue that these alleged First Amendment violations constitute election misconduct. The statute requires misconduct on the part of the election boards or any members thereof in any of the counties or of the state, or of any officer making or participating in a canvass for a state election. Both actions alleged to be misconduct took place months prior to canvassing and consequently cannot be considered misconduct under the statute, even viewing the allegations in light most favorable to the plaintiff. She has not stated a claim. And what the judge does is go point by point, each allegation, and shows that they did not support it with any facts. So I'm going to just, so here, second, in any case, the court may not provide the suggested relief. A court may provide declaratory judgment only after a justiciable controversy between plaintiff and defendant that is ripe for adjudication. The specific question of whether ARS 16-672 is adequate to protect plaintiff's federal rights and requirements was not in controversy between plaintiff and the defendants before declaratory action was brought. No proceeding lies under the Declaratory Judgments Act to obtain a judgment which is merely advisory or which merely answers a moot or abstract question. Count 10 must be dismissed because it is unnecessary by its own terms and requests an unavailable remedy. Plaintiff in her reply argues that the court has a justiciable controversy as to whether it may consider a trial claims in an election contest action, but this misunderstands the nature of the declaratory action. The justiciable controversy requirement is provided by a plaintiff's assertion of a legal relationship, status, or right in which the party has a definite interest and the denial of it by the other party. The relationship of the plaintiff and the defendants exists prior to the beginning of the declaratory action and does not arise, as claimed here, by the defendants defending against a claim right in the midst of litigation, so that count must be dismissed like the others. In her count 10, plaintiff alleges that certain actions in Maricopa County may have violated the equal protection and due process clauses of the 14th Amendment. Plaintiff states that such violations may be remedied by this court under 42 U.S.C. 1983, independently of the ARS, and claims that accordingly the plaintiff is entitled to an order setting aside the election in its entirety and ordering a new election. The statement is incorrect insofar as this court, the Superior Court of Arizona's single unified court of general jurisdiction, that may hear such claims under Section 1983. However, when, as here, the gravamen of her complaint is the improper conduct of an election, her challenge must conform to the provisions of Section 16-672. This court may hear plaintiffs' civil rights claims in a separate action, but they must be dismissed from this election contest as out of the scope of Section 672. Court 10 must be dismissed. So a lot of them were dismissed. All but two were dismissed, and the last two aren't even material to overturning an election. I mean, this is just really bad attorneys bringing really, really bad claims. So they would actually be a lot more successful if they were IRS attorneys. So if they were bringing claims on behalf, like say for subpoenas or summonses for the IRS, especially if they were in a tax court, they would be winning bigly. Instead here, even though they're on behalf of an elite client, the judge, Peter A. Thompson, actually applied the law. Again, that's right here. Which you know, hey, maybe they'll take this as a lesson. I don't know if they're going to be sanctioned for this garbage anyway. It would be wise. I think I would agree with the judge to sanction these attorneys. And Rule 11 does state that they are certifying it's based on a reasonable investigation into the facts and the law. So here it was clear that they had no facts. And it was most of it was tossed out properly. Unfortunately, they're going to probably appeal it and waste even more time. My tax money's got to go to that. I don't appreciate that. I mean, I'm just bewildered by the whole Republican thing of election denying. I got another video I'm going to be doing regarding that and the breakdown of logic. But here the judge did the right thing, which is nice to see. And to actually see it against someone like Kari Lake, who is rich and one of the privileged elite, you have to have a really, really bad legal position to come in as an elite and lose. So I guess you could say here, you got two elites. You've got Kari Lake and you do have the new governor and the former Secretary of State. So, you know, maybe that's what happens when you got two elites there. The judges have, they go by the law. Either way, and maybe because you had two elites going at it, maybe that's why the judge just evenly applied the law. It's so simple. Yeah. I mean, kudos to, I won't say the honorable, but I will say, kudos to Peter A. Thompson of the Maricopa County Superior Court for, doing the minimum. And that is applying basic principles here of court procedure that are long established and doing it evenly and not playing favorites like they tend to do if it's a little guy and a state actor or one of the privileged elites. That's going to do it for this particular video. I'm Mark Stevens. If you want to help support the channel so I can do more videos more frequently, you can do so in the description. And since we are coming to the end of 2022, thank goodness, next month, and I will do a video about that, letting everybody know I should be starting, barring all the tech issues, I should be starting up a live weekly stream again, and I'll have all the information on when you can hear that live. So that's going to do it for this particular video. Thanks for watching.